Okay, let's unpack this. Today we're doing a deep dive into a single legal case. And at first glance, you might think it's a bit localized. It's about a scholar in China sentenced for forwarding some social media posts.
Right. But the source material we're working with here, it just elevates this whole thing. It's not just a news story.
No, not at all. It uses this one incident as this perfect, crystal clear example of where a legal system can, break down. It really tests the absolute limits of justice and rationality.
That's the perfect way to put it. The person at the center of this is Dr. Chenjing Wan, an independent scholar. And he gets hit with this charge of seeking trouble and stirring up quarrels.
So our mission today is pretty ambitious. The sources analyze this single judgment through, 15 different lenses of Western legal philosophy?
Yeah, all the heavy hitters. From Aristotle and his whole idea about the rule of reason, right up to modern thinkers, Dworkin, Posner, people focused on integrity, on efficiency.
So we aren't just summarizing the facts for you. We're trying to pull out the universal legal principles that the sources claim were just completely violated here.
And the hook is just.
Yeah.
It's intellectually shocking. You have a man with a PhD in physics, specializing in something as rigorous as nonlinear complex systems theory.
Right.
And he's sentenced to almost 2 years in prison. For what? For spreading false statements online. The real question is, what kind of legal logic gets you from A to B? How does scholarly curiosity become a major crime?
That's exactly where we need to start. Let's ground everyone in the facts of the case. Who is Dr. Chen Jingwan?
He was born in 1976. He holds a Doctor of Science degree, as you said, and he describes himself as an independent scholar. He's into cross-disciplinary research, which, naturally means he's gathering information from everywhere, social media included.
And in 2022, he's traveling, he's in Kunming, and he gets arrested.
Right. On that charge we mentioned, Shuoster-Du, and it's often called a pocket crime.
What does that mean, a pocket crime?
It's just so vaguely defined that it can be stretched to fit almost anything. Any minor disruption, anything the state doesn't like, you can sort of stuff it into the pocket of this one law.
Got it. So he's tried, the hearing isn't public, and he gets a pretty significant sentence.
1 year and 8 months. And crucially, his appeal was just dismissed. No open hearing, no transparency, just denied.
Okay, so those are the facts. But the court's official logic, that's where things start to get really strange.
This is the critical piece. The written judgment actually points to his education as a key factor.
How so?
The court literally states that because he has a high educational background and knowledge level, he should have been able to discern right from wrong.
Wait. They used his advanced degree against him as an aggravating factor?
Yes.
That seems like a complete inversion of how that usually works. You'd think a PhD would be a sign of, good character, or at least a resource society wants to protect.
It's a total inversion. They built a presumption of guilt directly from his intellect. The thinking was, because he's so educated, he must have known that the content he forwarded was false information.
And by forwarding it, he was showing malicious intent.
Exactly. And that this act somehow caused serious public disorder.
That feels like incredibly thin ice. What was this evidence? What was he forwarding that supposedly caused all this disorder?
Well, this was the core of his defense. He argued the content was, pretty benign compared to the charge. The evidence was a real mix of things.
Like what?
Satirical art, like a cartoon, some personal emotional posts, candlelight pictures, but also complex academic articles, and even just objective data, like a digitized payslip of an old official. His whole point was, I'm just doing research here.
Okay, but the serious public disorder claim, did the court actually present any data? Were there mass protests, widespread panic, anything?
According to the sources, nothing. Not a shred of objective evidence.
So how small was his account?
Incredibly small. Under 100 followers. Many of them were like inactive accounts or personal friends. The idea that his reposts could trigger serious public disorder is, well, it's just not supported by facts. It's a judicial assumption.
A judicial assumption standing in for reality. So you've got a case built on presumption, minimal impact, and what about selective enforcement?
Yes, that too. He pointed out that the people who originally posted the content or the hundreds of others who reposted it, they weren't pursued, just him.
This whole structure where the state's claimed utility just crushes an individual, this takes us right into our first big philosophical critique. Ronald Dworkin and law as integrity.
Dworkin's whole argument was that law isn't just a set of rules you follow mechanically. It has to be a moral reasoning system. It needs integrity. And central to that is his idea of rights as trumps.
Explain that for us. Rights as trumps.
It means that our fundamental individual rights like dignity, freedom of expression, they act like trump cards. They have to override the state's appeal to just general convenience or, what's good for the majority. The state can't just say, well, it's easier for public order if we jail this person if it means trampling on their fundamental rights.
And in Chen Jingguan's case.
The court did the exact opposite. It took this abstract, totally unproven utility of maintaining order and used it to crush his actual concrete right to learn and express himself.
The principle was just thrown out for a vague policy goal.
Completely. And Dworkin talks about the ideal judge, the Hercules judge, who has to find the best moral interpretation of the law.
That clearly did not happen here.
The sources argue the judge was just a technocrat, executing a political instruction, not engaging in any kind of deep moral reasoning. The goal wasn't the morally best fit, just the politically convenient one.
So if the judge failed the moral test, what about the law itself, structurally? Does it hold up? And that pushes us from Dworkin into legal positivism to guys like John Austin and H.L.A. Hart.
Right. Legal positivism says, let's just look at the law as it is. A set of rules from a sovereign, morality aside. And even under that really strict formal framework, the sources say the judgment just collapses.
How can that be? I mean, if the court is the sovereign and they issue a command, isn't that law for a positivist like Austin?
Yes, but Austin's theory isn't just about force. The authority of law rests on the citizen's rational trust and habitual obedience, when the court just swaps out objective facts for political will.
And saying, I think this is a rumor, so it is.
Exactly. Then it's not a functioning legal command anymore, it's just coercion. It's what Austin would call bad law, and it destroys its own authority.
That's the trust issue. What about someone like Hart, who is all about the clarity of the rules?
This is where that pocket crime becomes so devastating.
Yeah.
Hart and Joseph Raz, after him, they stress that the basic rules of society have to be clear. But this charge is fundamentally, purposefully vague.
Which means the judge can just fill in the blanks with whatever they want.
Precisely. They call it unchecked free discretion. The lack of clarity in the rule itself means there's no protection against bias, no protection against political pressure. It invites an arbitrary judgment.
Okay, so we've seen failures in moral principles with Dworkin and failures in the structural rules with Hart. Let's pivot to a totally different perspective. Natural law. Specifically Lon Fuller, who said law needs an inner morality to even be considered law.
Fuller had this list of 8 criteria. For law to be valid, it has to be clear, consistent, not contradictory, things like that. If a system starts failing these tests over and over, he argues it stops being a legal system at all.
And the Chen Jingguan case.
According to the sources, it's a poster child for violating several of these criteria at once.
Which ones stand out?
Well, 3 are just massive. First, generality. Fuller says law must apply to everyone equally.
But this was selective enforcement.
Exactly. Punishing one high-profile scholar while ignoring all the other people who shared the exact same content, that's not a general rule. That's a targeted action. It's about who you are, not what you did.
Okay, what's the second failure?
Non-contradiction. The court's main argument, that a high degree means he must have known the content was false. Just an absurd, self-contradictory premise.
Right. If anything, a high degree means you need to look at more information, including things you disagree with. That's what research is.
Precisely. And the third big one is congruence. This is the link between the law on paper and what actually happens. The official rule says you need objective evidence of social harm. The official action was based entirely on subjective opinion and political readings. The two just don't match up. The inner morality of the law collapsed.
That covers the intellectual and moral costs.
Right.
But what about the practical, real-world consequences? This seems to take us right to Roscoe Pound and his idea of the law as social engineering.
Pound saw the law's job as balancing interests, individual, public, social, to create the least amount of friction and waste in society.
And the court here just abandoned that balancing act.
Completely. They gave absolute infinite weight to the state's unproven need for order, a public interest. And they gave zero weight to the vital social interest in things like intellectual progress and free speech.
So instead of reducing social friction, they ended up massively increasing it.
Absolutely. The main consequence was the chilling effect.
Yeah.
The fear this sends through the entire academic community. I mean, that's a huge amount of social friction. It's the opposite of good social engineering. It's socially destructive.
If we strip out the morality and just look at this through a cold economic lens, Richard Posner, Law and Economics, what does a cost-benefit analysis look like here?
The sources say it's just shockingly irrational from an economic standpoint. First, The costs. You've wasted the immense human capital of a trained physicist. He's in prison, not innovating or contributing,
Then you have all the judicial resources, police time, court time.
all for a nonviolent, low-level online action. And then you have the biggest cost of all,
Yeah.
the external cost. That chilling effect we talked about. It slows down the entire knowledge economy,
Right. And what were the benefits?
preventing some tiny, unproven chaos from a handful of reposts. When you weigh the massive costs against the zero or near-zero benefits, it's just a profoundly inefficient and irrational use of state power.
But if it's so irrational economically, there must be another incentive. And that forces us to look at the law not as a system of justice, but as a tool of power. It takes us to Karl Marx.
Yeah, for a Marxist critique, this suddenly makes perfect political sense. The goal wasn't ever economic efficiency.
It was ideological control.
Precisely. The pocket crime is used to protect the state's ideology. By specifically targeting an intellectual, someone whose job is to produce ideas and critiques, the legal system becomes what they'd call an ideological state apparatus. The punishment isn't for a crime, it's to enforce conformity. It's a show of power.
We've kind of come full circle back to the basics of reason itself. Let's finish with the critiques that hit at the very core of logic and the role of a judge, starting with, well, Aristotle.
Aristotle's foundational argument was that law should be the rule of reason, of the intellect, over the rule of passion and emotion. The sources argue that Chen Jingwen judgment is the total victory of arbitrary will of passion over reasoned rule.
The court did what it felt needed to be done, not what the evidence required.
And that violates Aristotle's core ideas of justice. It violates distributive justice because the punishment wasn't fair based on the act, it was based on his identity as a scholar. And it violates corrective justice because it completely failed to restore his fundamental rights to learn and speak.
And finally, let's bring in Benjamin Cardozo, the American jurist who thought so deeply about what a judge actually does.
Cardozo demanded that judges have methodological consciousness. They have to weigh history, sociology, logic, all of it. The judge here just threw out all methods. They used illogical presumptions, the I degree equals must know idea, and just arbitrary commands. The courtroom stopped being a place for reason.
So after running this one case through all these different frameworks, what's the universal takeaway for you, the listener?
The sources show a systematic failure. It doesn't matter which lens you use. Dworkin's morality, Hart's structure, Posner's economics, Aristotle's logic. The judgment fails every single test. It's inconsistent, irrational, inefficient, and it lacks any real moral foundation.
And if you had to pinpoint the one core breakdown that connects all of these different critiques?
It was a substitution. They substituted objective evidence, proof of harm, proof of a guilty mind, or mens rea with subjective political opinion. With an arbitrary assumption based on his education level, the court didn't prove a crime happened. It presumed a criminal based on who he was.
And this brings us to what might be the most tragic point from the natural law critique of John Finnis. The deepest problem here isn't just a mistake in procedure. It's a direct assault on one of what he calls humanity's basic goods, the pursuit of knowledge itself.
And just think about what that means. If a state punishes a scholar, a specialist, whose entire job is to seek out information and engage in dialogue, what message does that send?
Yeah.
It suggests that the act of learning itself can be dangerous.
So the final question really is for you to consider. Does a system that punishes the honest pursuit of knowledge risk destroying the very intellectual capital it needs to bid its own future? That's something to think about.